Hello everybody, and thank you for joining me for my webinar on helping your clients leverage community property trust to maximize their tax savings. We're not talking about the gift and the estate tax here. We're talking about capital gains. Capital gains is treated very differently, whether or not they're community property or separate property, and those advantages can be used even in Minnesota, and we're going to talk about that. And again, I'm Michael Redden. I am a wealth preservation attorney here in Minnesota. And what wealth preservation means is that I still do that traditional estate planning and business planning, but I have a heavy emphasis on asset protection, whether it's divorce or lawsuits or things of that nature, protecting your assets from those kinds of claims, as well as tax planning. And I'm also a member of the Society of Trust and Estate Practitioners, also known as STEP, and that is the international organization because I do quite a bit of cross-border planning as well. And I'm also a member of Wealth Council. So why community property trusts? Well, essentially, in America, we have two separate property regimes under the law. We have the separate property, which we have in Minnesota, and that is that each spouse, when they hold their asset jointly, if their home, for instance, we can divide those halves. We can tell what the husband's half is. We can tell what the wife's half is. They each have their own different basis, and we can pull those apart. For community property, we can't do that. We say they have an undivided half. You can't separate the husband's half from the wife's half, so they really have the same basis and the same tax characteristics. And why is this important? Because we all have those clients we know that have resisted our planning, and they have those low basis assets, whether it's a business, vacation home, or something else that they may be a little bit more attached to. And they're not wanting to put it in trust or do any kind of succession planning, so we know they're going to hold it till the day the first spouse dies. And this is really the situation where this technique can assist you in saving hundreds of thousands of dollars in taxes for your clients. So what kind of property is covered? Well, there's businesses, homes, that could be the vacation home. It could also be the personal residence. If, especially under tax reform, they haven't owned it for 5 years when they pass, or if there's $250,000 greater than $250,000 in gain still within the property, should they be wishing to sell it. Rental property, of course, stock and mutual fund accounts, pretty much anything that they can own jointly that has a tax basis and has a capital gain inside of it. Anything like that can benefit from this technique. So, like I said, separate property leaves at least half of the gain taxable. That's because on the first spouse's death, just that divided half we can separate out gets a savings and capital gains, because when that person dies, say the husband, his half now becomes a basis of fair market value, but the wife's half still has that gain trapped inside. Community property, since we can't separate the basis, they really only have one, those increase to fair market value so they can be sold with no taxable gain upon death. And why is that important? Well, a lot of times here in Minnesota, when we have that separate property, when that first spouse dies, there's still taxes due. And those taxes make it to where it's unlikely that the surviving spouse is going to sell those during their lifetime, even if it's not suitable for them anymore. Even if it doesn't produce enough income, they just can't handle the taxes. They can't handle that tax consequence. But if it's community property, they can sell it with no tax consequences after the death, and we don't have to worry about those issues, and we get them to better, more suitable assets. Now, Minnesota is a separate property state, but your clients can still own their assets as community property. This technique will make Minnesota property, even though it's in Minnesota, like real estate and separate property, this will make it community property. So if you have a client in this situation, I'll remind you, and you can email me at the email address there, you can give me a call, we can go over the fact pattern. If they're going to use another attorney, we'll talk it through, and we'll look at the various options for your client. At least you can take some of those options to their attorney if you'd like, and you can work these benefits out. So now we want to look at a case study of how this actually works. So we're going to look at the typical Minnesota client. This is Philip and Teresa, and they hold together jointly a home and a brokerage account. So let's look at just their home, and we're going to assume that They haven't owned this home for 5 years, even though they probably have for longer with this one. They certainly do have larger than the $250,000 capital gain involved, so it's an issue for them. So they bought the house for $60,000, but since we're in Minnesota and we have separate property, they each have their own basis. So they paid $60,000. Philip has $30,000 basis, and so does Teresa. Now their brokerage account has $200,000 in value in it when they first put the money in. That was $200,000 that Philip got from an inheritance from his father passing. It was put in a joint account, so half of it was Teresa's too. So $100,000 basis for Philip, $100,000 for Teresa. Fair market value is $500,000. So let's kind of compare how this plays out if unfortunately Philip should pass. Under separate property for the home, the basis is going to be $280,000. That's because Philip's $30,000 basis increases to $250,000 for his half. Teresa's basis remains $30,000. So combined, $250 plus $30 is $280,000. There's still $220,000 of capital gains contained in the home. And if Teresa waits a few years before selling that thing, it's probably going to be above $250,000 and we'll have some tax due. If she's only owned the house for less than 5 years, then we've got the entire tax due. So if it was community property for the home, we can't separate the basis. So when Philip dies, everyone's basis goes up to $500,000. There's no gain left. You can sell it with no problem, even if you've owned that house for a short period of time. Now, for the brokerage accounts, Philip's $100,000 is going to increase to $250,000 for the half. If you add Teresa's $100,000 to it, we're looking at $350,000 for the basis. If it's got $500,000 in value, there's still $150,000 in capital gains that will have to be recognized as she liquidates that account. Now, if we look at community property, same thing. Once Philip passes, all the basis jumps up, and it can be sold and liquidated with no capital gains liability. So how can you help your clients save hundreds of thousands of dollars in capital gains taxes if they are holding joint property? Alaska, Tennessee, and South Dakota allow non-residents to create community property. They've got laws in their books that allow for even residents of Minnesota to take advantage of this tax regime. And they do this through a special trust that was created for this purpose called a community property trust. And what this trust does is it says, hey, everything I own inside of here is community property. When the first spouse dies, I'm going to stop existing as a trust and give everything back to the surviving spouse. And since it's community property, everything got a step-up basis, and there's no gain remaining. Alaska trustees have been doing this since the late 90s, and they've never had one challenged by the IRS. I mean, think about it. If they challenge this, then you've got the IRS, the federal government, treating the state citizens of Minnesota and Alaska differently. That's an equal protection violation. They can't do it. If that option is available, they certainly can take it. Minnesotans can make these trusts, and when they make it, even Minnesota part of that house inside becomes community property to get the benefits. But they've got to have a good marriage. Community property is treated different. Under separate property, we've got equity, we've got fairness. One spouse could get more than the other. Under community property, it's assumed to be equal ownership. It's assumed to be a 50-50 split, and that cannot be what's desired. So make sure they know about that or they have a good marriage. Depending on their age, even if there's $100,000 of capital gains inside there, that they could probably benefit. If they were 65 and 65 and they put assets into one of these trusts, usually the special trustee fee that you have to use a special trustee, say in Alaska, it's about $3,500 a year. Over 10 years, they may have paid $35,000 in trustee fees, but I bet that $100,000 in capital gain might be $175 or even $200 by now. And so they paid $35,000 to get no tax liability, whereas without that, now they've got to take 25-35% of maybe $200,000. As you can see, do the math there, that's twice what they paid if it gets to $200,000. So there's still a lot of benefit with that. And if you need experienced help to put these for your clients, I've definitely been involved in these, and we can set those up in any state. Just give me a call and we'll discuss it, or send me an email. And I hope you enjoyed this webinar and found it valuable. And I certainly do welcome you to any future ones. Give me a call. We'll talk through any client situation. Have a nice day.